you, everybody, for joining us today. Welcome. Have a seat anywhere. So I understand we have 5 classes here today, including my class. I see a few people. Great. Stay to the end. We'll have a QR code, of course, for your attendance, right? Great. There, show me your hand if you are in the business law class. I just want to see where my team is. Okay, great. If you're in accounting or finance, another business class, marketing. Okay, great, great. How many of you have worked in any way with intellectual property? Raise your hand. Not very many raising hands. Have you ever authored anything? Raise your hand. You've written a paper? Are you new in school, right? If you've written a paper, you have authored something, and the moment you created it, you have some copyrights in it. Copyrights are intellectual property. Do you have a website? Yes, intellectual property, copyrights, maybe trademarks, maybe even some of you have worked with patents. Hand raise? A few. I see a few in the back there. Great. Well, today we're going to touch a little bit on the basics of intellectual property, not so much from the legal standpoint, but on the asset value standpoint. So if you're in business or entrepreneurship programs, this should be interesting for you. We're also going to talk a little bit about AI, artificial intelligence. Who's using AI in any way? Almost everyone. Who's used it in class? You're allowed to raise your hand. It's allowed. Yeah. Okay. Who's used it for research? Okay, good. Who's used it for writing? It's okay. Yeah. Who's used it for idea generation? Okay, great. You guys are pretty active and pretty familiar with it then. This should be fun. Let's make it interactive. What do you say? Thumbs up? My class should be used to this? Yeah. Let's make it more interactive today. I want to talk a little bit also about patents and our patent forecast visualization, how some AI-based software can help you see what's coming in the future of inventive solutions to problems. We'll get to this near the end. But at the beginning, I want to talk first about IP. If we're going to talk about IP in the age of AI, we better first know a little bit about intellectual property. Why do we care about intellectual property? Anybody? What does intellectual property do for you? Yes? It protects your ideas from being stolen. So there's IP thieves out there. Are IP rights valuable? Henry? Yes, they are valuable. We care about intellectual property rights because they can give to the owner, the rights holder, a limited monopoly. Are monopolies good? Who thinks yes? Are they bad? And raise. They can be good or bad, which is why limited monopolies are allowed by the government if you participate in an exchange, right? If you're the business owner, the IP rights owner, they're good for you. You keep your competition out. That's part of the value. So the greatest value is in enjoying the entire market to yourself, to charge what you want, to have customers wherever you want. There are limits, of course, time limits. But we care about them because we've created something valuable and we want to enjoy those rights. What is IP? What is it? We've heard someone say these are a way to protect people from stealing ideas. So what is intellectual property? What's a type of it? I mentioned them earlier. Do you want to play the game? Yes. Patents. Patents protect inventive solutions to problems. Usually they are functional things. We think of them as complicated occasionally, but they don't have to be. Patents could cover any form of technology or science, and they can even cover software. They can cover video games. They can cover games. They can cover toys. They can cover services, even business models. How many of you own crypto? Cryptocurrency? Yes. The blockchain and cryptocurrency is a whole area of growing patent applications. Lots of value in that. Digital wallets for your crypto, covered by IP. These are all patent covered. How about this book? Copyrights? Yes, if I wrote it. We'll get into that in a second. So intellectual property is mostly about excluding others. They're negative rights. Do you have to sell something that you patent? Who says yes? Who says no? You're right, you don't. You don't have to. You just get to keep others out of your property. You don't have to build anything on it. Think of it like real estate. You buy the land, you can hold it. You can keep others off, you can allow them on. You can build on it. The more you build, the more the return. Trademarks, you have to use in connection with goods or services. All of these are valuable. What about data rights? Are those intellectual property? Who thinks yes? Who thinks no? You have to choose. Come on. Who thinks no? Data is one of the top newest considered IP rights that exists, but it's been around. It's been that way for a while. Most of it's trade secret. Your customers, your revenue information, in the financials area, your marketing, obviously you have a strategy and you have information around that, but the response rates, what campaigns are working, data is a valuable resource. Where do the rights come from? Again, if we're going to talk about intellectual property in this era of AI, we'd better know, where did the IP rights come from in the first place? Anybody know? They come from the government. Okay. What's the source of IP rights by the government? Any idea? I like hands raising.
The Constitution gives the right to the state to give out patents, for instance. So these are rights that, while they are not derived from the government, they are recognized by the government.
So the federal government, under the Constitution, is the source of IP rights. Please pass this down to our first participant. Thank you. The Constitution, that's right. Article 1, Section 8, Clause 8 is often referred to as part of the Commerce Clause. So it gives Congress, the US Congress, the right to make laws to give for limited times to authors and inventors the rights to protect their creations. So that's the initial source of rights. And then what? Then where? The US Patent and Trademark Office, which was founded by one of our founding fathers. That's right. Anybody know who? Which founding father of the United States of America is usually thought to be the father of the US Patent Office? You don't want to play the game. Oh, come on.
I'll just take a guess.
No. So a founding father, someone earlier. earlier. The founding of our nation. That's all right. Thomas Jefferson. That's right. Thomas Jefferson, who happens to be the president on this $2 bill that I'm passing out. It actually is real money. Yeah. And on the back is the signing of the Declaration of Independence. It helps us remember the source of IP rights. It's part of the founding of our nation. And it's part of what has made the U.S. economy so robust and so strong. So the source of IP rights coming from our Constitution is important to remember. And then from there, the federal government, the Congress, remember the Commerce Clause gives Congress the right to make the laws. So the Constitution enables it, and then the US Congress has made laws to cover copyrights, patents, trademarks. And obviously trade secret law now is covered as well. So it's the Congress then that makes those laws called statutes, right? We have a law school here now. No one's here from the law school, I don't think, but yes. Are you in the law school?
Yes, ma'am.
Excellent. Awesome. Thanks for repping that. And your friend also. Great. Inaugural class, you both have some participation here. Let Dean Martin know you care about IP law. That's good. Excellent. And then from there we have the statutes, but there's also another type of laws. What's the other type of laws that can govern intellectual property? Statutes are passed by Congress. There are other types of laws that cover it. My law students?
You have regulations from administrative agencies.
The regulations do come from the agencies, but someone in my class will know that litigation gives rise to case law and common law. So there are some common law rights in trademarks and copyrights. That's correct. So now we know that laws govern intellectual property. It's also going to affect what we can do, therefore, when AI comes around, right? So as long as we remember the source, we can still play the game, don't worry. The source of the laws is from our Constitution, from the federal government. The states do have some rights to address intellectual property in contracts, et cetera, and at the common law, but most of the time it's US federal. So we would be looking to the federal government. Why are these rights important? They're important in business because they're property rights. They're transferable. So we heard earlier, IP protects your ideas from being stolen, and you don't have to use them, but you can. And you can transfer them because they're property rights. That means you can make money even though you don't make or sell anything. How does that make sense? Oh, yes. Patent trolls. Who's heard of a patent troll? What is a patent troll, sir? That's right. A patent troll is a person, hopefully better looking than that, or an entity. It could be a company. It could be a company, and they don't make or sell anything. Only they own patents. And what do they do with them? How do they get money for them? You charge people, but how do you charge people? You can sell a patent or you can license it.
You can sue them
Oops, there's that thing. You can sue them with your big stick. You can sue them for patent infringement and then buy shoes, right? Get some shoes to cover your troll feet. you can sue them. So does that really work? Do companies make money that way? Well, let me tell you, recently there was a case at the beginning of July that a jury awarded to a patent troll $847 million on two patents. Two patents. Does that sound like a good business? Yeah, it does. Even this month in September, there was a recent case of a patent troll awarded against Samsung for wireless charging for nearly $200 million for 4 or 5 patents. Are patents valuable? Oh, yes. Are they dangerous? Depends on who owns them and what they do with them, right? So this was actually obviously a pretty negative piece of advertisement that was run. A group of Silicon Valley tech people ran this to try to promote legislation in the federal government that was so-called anti-patent troll, or the Protect Innovation Act, it might have been called, that failed to move out of committee and to be passed as law. But why would we want to stop patent trolls besides they're ugly? Are patent trolls a good thing or a bad thing? We now know that you can make money as a patent troll. Is it good or bad? It could be bad. Johan thinks they could be bad. I don't like that answer, but I'm going to reward the game. So thanks for participating, Johan. It could be bad if it stifles innovation, if it prevents other companies from doing the thing that, oh, wait, your patent says is only your territory. So they have the right to keep others out. So if it's a bad thing, why would we not stop them? Because it would ruin the patent system. It's a personal property right. So just like this clicker, I could sell it to you, and then you can do whatever you want to by keeping others out. You might like to run a business. You might like to become a patent troll. It's up to you what you do with it. But if third parties are on your property, shouldn't you be able to keep them out? Some people say patent trolls are not ethical. They do occasionally make a lot of money. Do you remember BlackBerry? I usually bring my phone out to show iPhone, right? But BlackBerry was a pre-iPhone version where it had little keys, like a tiny keypad. They were dominating in the US smartphone business very early. Until about mid-early 2000s, they were sued by a patent troll called NTP, who only owned patents that they bought from someone who created them. So there was that transfer. There was some value for that. But the patent troll invested money, sued BlackBerry, and nearly won injunctive relief to stop BlackBerries from operating in the US. Now, the BlackBerry manufacturer RIM, R-I-M, Research in Motion, it was a Canadian company. Wait a minute. How does that make sense? It's a US federal law that creates our patent or our IP, but a Canadian company that's being affected by it. Why would that be? Any ideas? If they're operating in the US, they need to abide by US laws. So it applies to anyone who wants to make, use, or sell or offer to sell in the United States. They were able to reach a settlement, an agreement to stop the litigation with RIM just days before the injunction was likely to go into place and tank their business in the US. They settled for $612.5 million the first time. And then they came back with other patents a few years later for almost 300 million more, almost $1 billion. If you couldn't transfer those rights to someone else, you wouldn't be able to have value from the patents, from the copyrights. Even trademarks can be transferred. So we want to have the free transfer of rights, even though this made it look bad. Patent trolls actually return money to independent inventors who very often can't run their own business. How many in entrepreneurship here? What are the stats of businesses failing? Is it high or low? Ariana? It's very high. The majority of businesses that are launched do not succeed past 2 years. Every business is started by an entrepreneur. And a lot of times there's IP at the start of it. Who creates IP? Who creates IP? Everybody can, not quite. This is where we start to restrict. This is where we begin to come into the age of AI. Everybody here is using AI. If AI writes your paper, can you turn that in? Don't answer. No, you cannot submit the writing that your generative AI did for you. You have to submit your own writing here as part of the honor code because it's not ethical. But you can't register copyrights for it, so you're not really writing it. It's not really taking you where you need to be. The laws in the US provide that most intellectual property is created by people. So in that way, it is sort of everybody, Jackson, right? Human beings. I believe that human beings were all created in God's image and likeness, and we all have the power to create, and we create with our words. With words most of the time. Patents are created with words plus drawings, trademarks, words plus images, copyrights, words plus images. But people create them. So the US Congress actually has written most of the IP laws to require a person, a human being, to create. This is where we start to get on the tip of this. Has anyone heard of the copyright case with the chimpanzee? Oh, come on. You don't think that's a well-written paper? Not a good drawing? Not beautiful art? How many of you have ever taken a selfie? Oh, yes. Come on. Admit it. We've all done it. You've probably done it today, right? Okay. You could register copyrights for your selfie. A chimpanzee cannot. Even though a chimpanzee allegedly took a selfie, and so someone thought that would be a great thing to submit to the US Library of Congress for copyright registration, and they listed the chimpanzee as the creator, as the author of that beautiful photographic work. Copyright, yes or no? Hands up, yes? Hands up, no? No copyrights for you, not a human being, you cannot register the copyright. Do you see how then the laws applied and the case, the litigation around this type of thing begins to help us understand how the IP laws will evolve as we get into AI? Had a brief conversation just before this lecture started about, are the laws leading or lagging technology? Who thinks leading? Laws come to help lead the way. My law students, leading or lagging? Laws are always lagging. It's effortful to have laws passed in the federal government and in state governments. Even case law takes time. There has to be litigation filed, and it takes years often before the result of the case law, even if it's precedent, can be applied. So the laws are always going to be a little bit behind. So when we see this move toward rejection of non-humans being able to register copyrights, then we think the current state of law in the US is going to be consistent with that, right? Yes. Is AI human or not human? AI human? This is called artificial. AI not human. Hand raised. Can AI generate content that can be copyright registered? Hand up. Yes? You think yes? You think yes? You say no. Why not?
Oh, just because it's like the chimpanzee example before, it's not.
Exactly. It's just like that. It's not a human. A human didn't make it. Except that there was a first copyright registration for AI-generated book, a picture book. It turns out Midjourney developed it. Just a second. Midjourney developed it. Chris Castanova decided to use Midjourney to create basically a comic book, a dystopian picture book, if you will. And using publicly available Midjourney, created every single one of the images in the book. Every one. And then filed for copyright registration. It took a lot of work to generate those images. That was the argument. It registered. The copyrights were registered. Unbeknownst to the Library of Congress and the Copyright Office, that generative AI had made it. And so, doing what we would all do, go to social media and brag about it, the author did just that. The Copyright Office was notified, and the copyrights were clawed back. No copyrights for you. In the ensuing exchange and arguments about that, the argument was, but I did all the prompting. The author said, I did all the prompting. It was thousands of prompts for each image. It was a lot of work. No copyrights for you, except the sequencing of the images was permitted to be copyright registered. And it is now very clear, based on these cases, the chimpanzee case, the Midjourney author case, if you will, that you must disclose to the government if you're using generative AI in any part of what you're applying for registering intellectual property rights. And that includes patents as well, but copyrights absolutely. So if I decide on my next book, instead of authoring it and writing it, having it edited, if I decide to use generative AI for part of it, can I register copyright for my book? Who thinks yes? Who thinks no? Johan, you're thinking yes. Tell me. Very good. That's exactly right. I can't do the whole book without disclosing, but I can disclose what I did contribute. And for those parts and sequencing of chapters, et cetera, I can register the copyrights. Is that valuable? Yeah, there's still some value in that. What if you use one of the generative AI, I think 10web.io, you can make your own website in way less than 15 minutes. If AI generates your website, can you register those copyrights? No. What if you took images that are included on it? Yes to the images. Whatever you've done, perhaps you can register, but you must disclose everything. I'll come back to that in a second. Trademarks, though. Yes, sir.
I find this all very fascinating. I'm curious, how does the court distinguish between AI tools and just like non-AI tools, like MS Paint to create an image versus Midjourney or something? I mean, I could use Midjourney to do very simple step-by-step things that would mimic MS Paint or something. I don't understand if there's any legal distinction between AI and non-AI.
So it's about who's controlling, or who's, if you will, controlling the pen. If you're merely using like Adobe or some other software that lets you do computer graphics, so you can create something digitally, but it is by your hand, by your pen, then that's yours. If you're co-creating with another person, great. But merely prompting or saying, I want more like this or more like that, all of the generation being done by AI, not by your hand, if you will, is going to be the difference technologically. So it's kind of like the Grammarly. Is Grammarly a generative AI, or is Grammarly just spell checking and fixing your grammar? Where's the bright line? Most of the time, the bright line is whether or not substantially that's your material or your work. I have a daughter who's in the studio art program here, and she uses a lot of computer graphics programs, but she's coming up with the image that ends up being on by her hand, making it on the computer. You could imagine voice activation becomes not such a bright line. If I'm telling it to add more red and it adds red, was that AI or was that me? So when we think about copyrights, I think that is going to become probably a little bit more difficult to tell. So why would anybody disclose it? This becomes the ethical question. Why would you tell the Copyright Office if you know they're going to turn you down? Who would like to just file the application anyways? Just apply for copyrights, even though, you know, you didn't make the whole thing, but you're kind of like, I did a lot of it. Why would you not do that? I see a lot of talk on social media about people who are like, yeah, I'd do it. What do you think?
You can get sued in return by the baby because you disclose it.
They could sue you to take it back, so you might lose your registration. If you're not honest in your applications and it comes out later because you try to enforce, this is where it will come out. You try to enforce your rights to keep third parties out, and then it may be discovered through litigation that you, in fact, have no artistic talent whatsoever and have never made anything in your life. And there you go, that this has been generated by AI. You will not only have unenforceable rights, but you may be banned from applying for other IP rights from the US government. There's a duty of candor before the US government. For copyrights, trademarks, patents, you have to be honest in your applications, or even if you get rights, they won't be worth anything. We've heard about how valuable they can be, right? Let's talk for a second about patent value through merger and acquisition. And let's pick on Google, right? Because they're big and they have deep pockets, right? Google buys companies very often because they have exclusive rights through IP that Google doesn't have. Who thinks that's true? Yeah, it is. Let's talk about a couple of them. This is very consistent over time. These are a few of the big ones. Google's M&A. 2012, They bought Motorola Mobility for over $12.5 billion. Why did they need it? They already had the Android handset, the Google phone. They didn't have very many patents. Apple's not going to share that. Samsung's not going to share it. So they turned to a company, Motorola Mobility, that wasn't doing very well. They had manufacturing. They had product in the market. After they bought Motorola Mobility, they sold off the operating units. They didn't need the manufacturing. They didn't need the invention from ongoing resources. They needed the patents to keep others out and to not be sued by other companies. Let's look just another 2 years later. How about Nest? Who's heard of Nest? Nest? What does Nest do? They do smart thermostats inside your house. Who thinks that's a big business? Yeah, remember I talked about data just a few minutes ago? They capture a lot of data, right? Google bought Nest for over $3.2 billion. Just thermostats. There's a lot of data there. It's a big business. And Nest had a lot of patents. And what happened right after that? Litigation between Honeywell, which also makes smart thermostats, and Nest, Google Nest, that lasted for years and went into the hundreds of millions of dollars until they settled. You might wonder, how did they stop that litigation? They cross-licensed. So sometimes you need the patents just to get things resolved. Probably Honeywell started it. Fitbit. Who knows about Fitbit? Fitbit, a more recent acquisition by Google. And remember, Apple also had its smartwatch, and they started all of them adding for consumer sleep. Who lets that stuff track your sleep? Tell you if you've had a good night's sleep. They know how you sleep now. How about that? The data is so important. But how do patents help with data? If you can keep others out of making the device that collects the data, you have exclusivity to the data. And it turns out a lot of companies monetize the data. Do they do it with your permission? Who thinks no? I see a lot of heads shaking no. How do you know? They're stealing your data? It might be, but how do you think? Why do you think that? Oh, that's okay. Go ahead. Oh, terms and conditions. How many of you remember signing terms and conditions for an app on your phone? If you click and you're using the app, you've come into agreement with the contract for them to use your data almost always for free. So you probably did end up agreeing to that. So data and then IP rights that help you have exclusivity to obtain the data, really valuable and really important. What does this have to do with AI? Can AI manufacture data? God bless you. Does AI make anything? Really? Can it make data? Yes? Maybe? Who says yes? How can it make data? You could do that. So let's do. You can do almost anything with AI. It turns out AI has some limits too, and it's not just limits in IP, but it turns out AI doesn't really come up with things on its own. it makes combinations of things that are out there. Have any of you asked it to give you data or to do a calculation? My finance guys? Yeah. Does it come back with the right number? No, it hallucinates. It makes things up. It often will make things up. I don't really quite understand why that happens, but if it doesn't know, if it can't find all the answers, it very often does make things up, which isn't the same as having data that's reliable or accurate, but it can give you some information. Most of the time, people aren't aware of that. And this is why, to my young lawyers, future lawyers, AI can get you in trouble if you're asking it to write your brief. It will hallucinate cases that don't exist. It will give you wrong citations. It's not good at that yet. And you will get sanctioned and fined. So far, the fines for lawyers who are using AI and don't check the work have been between $5,000 and about $10,000 or $12,000. So not really big fines, but you don't want that fine and you don't want the case to be lost because your brief was wrong, right? Absolutely, absolutely. Well, let's talk about this because I do want to get more into what you can create. Just briefly, this is my challenge to you. You have unlimited ideas. We've talked about this before. Who journals in here? That's a resource. Who digital journals? Right? So you could layer AI on top of your own journaling and come up with material that you yourself actually did write. That would be a way to put things together that you authored if you restrict it just to that, which is interesting. How about solving problems? What about patents? What if AI invents, but not from your material? If it comes up with a patentable invention, a solution to a problem that you queried it for, you did the prompts, can you patent that? We haven't talked about this yet. It's my last IP question. It turns out that a researcher did generate a machine, if you will, an AI machine, and he says that the AI output an inventive solution to a problem and applied for a US patent for that invention. He also applied in almost every other country. You have to go country by country. Who thinks the patent was awarded? Hand raised? Who thinks, yes? Why? Why do you think that's okay?
Just because it seems theoretically that any invention would have independent value regardless of whoever created it, and that value is what's being patented in that situation.
So that's a good argument that really it's about the inventive solution, because the whole point of the patent system that Jefferson helped to stimulate in our country is that you're providing to the public an inventive solution to a problem that's never been out there before. It's new, it's not obvious, it's beneficial to society to get it out there. If you disclose it in exchange, you may be awarded a patent. There's value there. That's a good argument. However, because in the US, the laws say you have to be a person, and in the US, you have to name an individual person as the inventor. In the US, there's still no patent for you. Now, he has litigated to say, but really, I didn't invent this. I created the machine that invented this. So he can't apply for a patent on his own anyway. He's stuck in that bad zone. Yes, sir.
Do you think that he could argue that he was inspired by AI, but that inspiration was limited in nature, and the true work of invention was done by him?
He could. That is a good argument. I can tell that you're in your first year of law school then, right? Making good arguments. He could argue that, but he didn't. He chose to apply because he wanted to prove AI can be an inventor. He wants to be known as the guy who made the machine that was the first non-human inventor. Well, In the US, the answer is no. So he can't now say, whoops, really, I was the inventor, because something's not honest about that. In every other country, he did the same thing. And it turns out, even though through the International Patent Cooperation Treaty, a company can be listed as the applicant, and a company is a fictitious entity, right? So it's not a person. A company can be the applicant. Most countries said no, their country laws also require a person to be the applicant, except it turns out in South Africa. His patent was granted in South Africa because they do not examine, they do not make the substantive, almost if you apply for anything, you will get it in South Africa so far. And I think Australia is starting to consider whether or not they will allow it, but so far, no. So that comes back to no. If you are AI, no IP for you. Once again, with patents. Except, now we're going to get into some technology that I really like. Robotics, collaborative robots, humanoid robots. What do you think about that? All my business people. Do you think robotics is big business? Do you want some numbers on robotics? Here we go. In 2022, the global robotics was purported to be $34 billion market. This year, $46 billion. That's a pretty big increase in 2 years. Some information shows industrial robotics alone will be $163 billion by 2032. Robots are a big business. Humanoid robots, which are like collaborative robots, it turns out might be the first AI that can invent. This is my hypothesis. Because there is a humanoid robot named Sophia. Beautiful Sophia has no hair, but beautiful Sophia interacts because of AI. She has an AI brain. She has feelings, allegedly, maybe for you or you, but she has been made a citizen of Saudi Arabia. Normally, only humans can become citizens of a country. So I think this is the legal slippery slope. If a humanoid robot can become a citizen, then a humanoid robot who is a citizen should have the rights of a citizen in that country to file for a patent application. And if Saudi Arabia is a member of the Patent Cooperation Treaty, then they would be able to file through that and be able to reach into the US. In the future, that may be a case to watch. It's not happening yet. She hasn't invented, but I'm calling on that. One area that you can use generative AI for to stimulate invention, your creative thinking. Tell me your name, sir. My law student back there. One of the two.
John Taylor.
John Taylor. Thank you, John, for answering that. So John suggested, but what if it just gave him some ideas and then he put them all together, synthesized them, and he invented from that? You can do that. Most patents are new combinations of known things. That's a great use to stimulate AI. Help me think of alternatives. You make the final decisions and choices. So divergent thinking, stimulating your thinking. You can only invent or create from what you know. The more you read, the more you see, the more you know, the more you can invent and create things. So using generative AI to get exposure to more things in your area would be helpful for creating IP. Thanks, John. I appreciate that. So today we're mostly talking about IP in the age of AI. The IP miracle is really the other side of this coin, which is How as business people and why do we care about IP rights? They help you make money. They help increase the value of your business. If you want to raise money, how many of you have started a business? Yes. What is your business, sir? Power washing. Awesome. Your business. Lawn care. Other businesses here. Couple of businesses that have had IP. I remember earlier. Yeah. So if you have started a business, you know that you make revenue and then you make profit. If you want to sell your business, who would want to buy it? A bigger company in that area, potentially doing a similar thing, a company that wants to get into that area. A bigger company, remember what we just talked about with Google, a bigger company that doesn't have IP that you have. It increases the value, the valuation of your business beyond your revenue, beyond your profit. So always look to all forms of the IP when you're thinking about the value of your business. And AI, again, can help you think about that. Here's a whole business that I found really fascinating as I began to get into the world of generative AI. Rafiq Anadol is originally from Turkey. He lives in LA. I met him when I was on a trip to Dubai a year and a half ago. And he spoke at the Museum of the Future in Dubai. Really a fascinating place. I recommend going. But he has a business. I guess he's an artist, his art business, and he has a whole team that implements with him, including partners for the technology that you must have to generate your artwork, Google and NVIDIA. NVIDIA chips power a lot of the AI, especially for video games, and of course, Google for cloud compute. These are two essential things for generative AI to work. You need compute, and you need the chips that do it very quickly. It's expensive, but he was able to, this is part of his work. I think this is our pointer here. This is part of his work. It was a continuously changing dynamic work of art that ingested all of the artwork that's ever been at the Museum of Modern Art in New York City at MoMA. And then it was the AI let loose to make whatever it wanted to make. The project was called Unsupervised. Copyrights for him? No, not at all. Is the technology behind it patented? NVIDIA chips? Google Cloud Compute? Yes, so he has deployed it in a new way. Could he file for a patent on that? He probably could. It was his idea, so he may be able to patent but not copyright the outputs, but patent the method of generating dynamic, ever-changing art from other works of art that don't resemble it whatsoever. But extraordinary, he also combined sound from inside the viewing area and the weather from outside to actually impact what the AI did with the art. Otherwise, unscripted, but no other IP rights in it. So as you begin to think about yourselves as business people, most of you are in entrepreneurship or business, marketing even. You want to generate marketing collateral, ideas, generate a lot of ideas quickly. You can use the generative AI for that, but not secure the IP rights. Make sense? So why did I write this and why do I care? There's a lot of misconception and people filing for copyrights that don't know they have to make the disclosure. And we talked about the downside of that. Your rights are worth nothing, you can't enforce it, right? So use it to stimulate your thinking, but not to create the works that you think you want to register for rights. So it's a very good thing as you work on a team, you get a job in a company, to be clear about what's appropriate for you to do for that company. They want you to create the works very quickly, right? Marketing. Maybe creating pivot tables, the spreadsheets. What's the difference between programming code and using AI? There is a difference. You can register copyrights on the code, but not the outputs from the AI. So always be thinking about why you need it. This is a final point on the sequencing that I mentioned earlier. Let's talk for a few minutes about patents. I know that we have a little bit of time left. I want to leave time for questions. But our patent forecast software actually uses AI to generate these sectors. We want to see, just like Google Maps. Do you guys use Google Maps ever? Yeah. What if you had Google Maps, but for patents? How could that work? You want to come up with more ideas. You might not be the expert in the area. How many of you have heard of Steve Wozniak, another innovator in residence? How many of you heard him? Do you know about the WOZ project here on campus? A couple of years ago, they were working on autonomous vehicles and some brain-machine interface to give commands. The problem is, we're all students here, right? I'm a continuous student, but as students, you're not yet an engineer, or you don't have all the solutions that the experts in the industry would have. So how do you know where to start? Do you think Steve Wozniak knows how to do the next invention on that? He might, he's pretty smart, but that's not the work he's doing in the company anymore. So they have engineers that are working on that who are experts in that area. So to bring the students up to speed very quickly on what's the state of the art, what's the best inventive solutions to the problems in this area, we made the Google Maps for patents. We made patent forecast sector of brain-machine interface so they could see all the companies who invested in solutions in that area. That means they think it's important. They think the market's important. Obviously, Elon Musk Neuralink thinks it's important. He's pretty brilliant. So we want to think about R&D investments represented by the patent data. Who's investing? If you want a job with an innovative company, here's how you find them in your area of interest. Look at where they invest in patents. Who has the most patents? Who's investing and what do they do? It's great competitive intelligence. If you're launching your own company and you want to see who else is out there, if it's an inventive, innovative company, you can see what they're doing. Why do we not want to read all the patents ourselves? Great use of AI. Get the AI to read it for you. How many of you have read a patent? A few people have. Is it an exciting thing? Back row? No, not so much. It's pretty hard. It's tedious. It's very dense reading. But if you want to look at a whole bunch of them to see what's happening over time, how is the technology evolving and what's coming next? You can do that with this data. You can even identify what's happening. Let's talk about robots again. Collaborative robots or helper robots. The humanoids fall in this area. Well, let's look at who's investing in this area. Every dot on this diagram, trying to point to them, every dot on this diagram is a patent or a patent application and who the companies are. Here's one showing Verb Surgical. Robotic surgery is a huge area of application for collaborative robots. Now, each one of these patents, we could read them and figure out if we care about them or not, or we can let the machine tell us. What if I want to look at retail? I don't care about what's happening in medical. I don't care what's happening with the components about that or human interaction with it. I just want to know the retail side. Then I'm going to start looking at what Ocado Innovation International is doing. Now I've just found the company to start looking into to see what are they inventing. They're one of the biggest retail collaborative robots investors. And now let's look also at this market. This is a high growth rate. In fact, Goldman Sachs just did something they almost never do. Who's heard of Goldman Sachs? Investment bank. They're huge, right? They just issued an update report in the robotics sector 18 months after the prior report to revise it because the growth in robotics was so much more advanced than what they projected. They increased the economic impact by 6.3x just 18 months before the prior report. That's huge change. It's a huge market. When we think about exclusive rights of IP, they're more valuable the bigger the market. That's why most of those companies are investing. When we think about the countries, remember I said by country, where to go? This is data from Statista that's showing US is one of the top companies or countries that have companies. Here, let's pick Fanuc for industrial robotics. Do you think this is big business? $6 billion? $6 billion? A lot of what they're doing is just in the industrial sector. Let's look at Fanuc. They're number 3 in our list. But look, they're not retail. So if I'm interested in retail collaborative robots, I want humanoids instead of paying minimum wage people. Whoops, that's coming, guys, eventually, right? If I want to check that out. Then I'm going to look at Ocado. But if I want the robots in the factory, maybe because it's preventing human injuries, it's not just about replacing jobs, but it's injury prevention, it's safety related. We see the company to go to here is Fanuc. So just because you have a patent in an area doesn't mean it's in the neighborhood you want to be in. We have to look at big picture and drill down. Notice we haven't read any patents yet for my back row patent readers. That's a good thing, right? We haven't had to dive into detail and read them. We might want to once we realize the area that we want to go into. But the reason I mention this is Patent Forecast uses AI to make these sectors. Patent Forecast is patented and patent pending. But I invented it. My team invented it. And we use the AI to do the clustering and the grouping and the visualization. But just like Rafiq Anadol and his beautiful artwork, I kind of think these are beautiful. Maybe you guys don't. But I would recommend take a look at what Rafiq is doing and realize he could patent that, perhaps. All right, we're at that point. Whoops, don't do that yet. Q&A. Oh, that was the teaser. Thank you so much for your attention, everybody. I'll do some questions.